Get started. Thank you for joining us for another Truyo webinar. We are very happy to present to you today. The topic is how to collect health data with privacy in mind. The webinar will be recorded and you will receive the slides after the presentation. If you have any questions, please submit them to the chat module at the bottom of your screen. Presenters will answer them either throughout the presentation or after if time permits. Now I'd like to introduce our speakers for this webinar. First speaker is Dan Clark, president at Truyo and InterEdge. Dan has over 30 years of experience in technology, combining media, retail, and business leadership. He is a 9-time CEO and former Intel executive. Dan is a frequent speaker to privacy audiences and has been actively involved in Arizona, Texas, and federal privacy legislation. Our second speaker is Michael Helbush. Michael is founding co-chair of the Orange County chapter of the IAPP. He is also certified in U.S. privacy law and privacy management from the IAPP. He frequently presents on cyber-related topics, including data breach reporting requirements, protection of digital assets, student school privacy rights and obligations, and compliance with the EU's General Data Protection Regulation. And with that, I will hand it off to Dan.
Fantastic. Thank you, Ryan. Can you hear me okay?
Yep.
Great. All right. So for those of you who don't know, InterEdge, you probably know who we are, but we're about a 1,400 person software development company based here in Phoenix, offices all over the country and in the world. We do mostly security, emphasis, software development. And when we came together with Intel 4 or 5 years ago now to create a privacy platform, we ended up naming that Truyo. And Truyo is used by almost 100 or maybe over 100 very large companies to manage their privacy compliance with things like GDPR and CCPA and et cetera. And I'm very happy to be joined by Michael from Rutan. Michael, tell us about your practice.
Well, thanks, Dan. Thanks for having me. I love doing these webinars with you. It's been, I think we're probably at like a baker's dozen right now, something like that. But yeah, I'm a partner at Rutan and Tucker. I focus on data privacy, cybersecurity issues, and basically anything that touches the internet or sort of digital contracts I work on. Rutan and Tucker is a large California-based firm. We have offices in Orange County as our primary office, and then up in the Bay Area in San Francisco and Silicon Valley. And we do a lot of work. We're a full-service firm. We do a lot of work with employment issues, which is something we're going to be talking about a lot today. But we do corporate law, employment law, governmental law, privacy, data security, patent, everything. So happy to be here and looking forward to the webinar.
Great. Well, I love having you, Michael. You're just such a great resource, especially in the privacy landscape. We're going to go through and we're going to talk about especially a focus around collecting data and sensitive data in this COVID pandemic. But what's crazy is we conceptualized this webinar, 2 weeks ago? And since we created this topic and started thinking about having a webinar on this, there's just another breaking story that is so compelling that we decided we needed to lead with this now. And it just happens all the time in privacy where we think we're, okay, this is settling down. And then all of a sudden Virginia comes out of nowhere to pass a privacy law from the Senate a couple of days ago. And that kind of happened here. We're probably familiar with the ETS, the Emergency Temporary Standards around COVID in California, which is a set of laws that govern how you collect information on COVID and your plans and responses. And we're going to cover that in some detail. But surprisingly, on I think the third day in office, Biden signed an executive order which included a directive to OSHA to issue some guidance on how to collect data for COVID and what to do in a planned response. So in response to that already, OSHA on the 29th issued a set of guidance. Now, California is actually law. Is this actually the law, or is this just something we should pay attention to?
Yeah, so the executive order is an executive order. It requires OSHA to do what the executive order says, and the guidelines that were issued by OSHA federally are guidelines. They're not law, they're not regulation. They are information for companies that want to conduct the best practices with respect to COVID response for their employees and in the workplace. What is important about that is that OSHA was able to turn around this guidance so quickly because so much of it already maps what Cal OSHA is doing under the ETS. They're very similar in terms of what they require of businesses, what they tell businesses they should and should not be doing with respect to employees. But if you're going to look at the guidance for the federal guidance out of OSHA, you always want to make sure that you're complying more with the actual law, the actual regulations. And in this case, for Californians, at least, it'd be Cal OSHA's ETS.
And these do look, when I read the two of them, they seem very, very similar. As you said, ETS is law and the federal level is guidance. But I think we kind of have to take it seriously anyways. We're probably, if almost everybody does business in California, so you fall under ETS. And I think ignoring this is kind of at your own peril because it is federal guidance and plaintiffs will certainly point to it if you're not taking appropriate precautions. We also saw a senator introduce a bill a couple of days ago to withhold funding to states that don't pass a state version of this. Why would they do that at the federal level? Why not just make it a federal law?
Yeah, I mean, most of this is a federalism issue. The states have the ability to govern their own, to regulate employment laws within their own states. So something like a national directive would be difficult to enforce on a state-by-state level. There'd be some federalism issues there. This is obviously a response to President Biden's agenda of saying we want to get COVID under control. We want to take steps as quickly as possible to curb the pandemic as much as possible. And so the guidance is directly related to that. And I think that, the funding backing from the federal government for something like a contact tracing law like the one that was introduced is going to be a big incentive for states to really try to comply with those laws.
Yeah, so I think it's really important that we all pay attention to this. This applies to really all companies, large and small, whether you're HIPAA regulated or not, whatever industry you're in. And I think you really do need to pay attention to this. Basically, though, it says kind of the same things as the ETS, which we're going to cover. It says that you need a plan. You need a plan to try to protect your workforce as best you can, to try and protect your employees. We all want to do that anyways. We're all kind of doing that anyways. But you need to make sure and stipulate that plan and go through and have it written out explicitly. And you need to understand what kind of information you're collecting from a privacy perspective. How are you securing that information appropriately? How are you protecting that information? And importantly, it says that you need to cooperate with contact tracing, and you need to make sure that you're able to respond in the case where you have an outbreak or you have elements of this. And it does repeatedly point to the CDC standards to look at what to be alert for symptoms, for fatigue and cough and fever and things like that. So I think it's going to always refer back to that CDC kind of expert guidance. But this is something I think it's important for all of us to be aware of. Lots of us today are collecting temperature information and health data, and usually for the first time. Now, if you're a HIPAA covered entity, hey, this is standard operating procedure, right? You've been doing this forever. You already fall under the aerosol transmissible disease standards and HIPAA standards. Not a big deal. You know how to protect this information and keep this information. Most of the people on this webinar, though, aren't in that category. We're retailers, we're tech companies, we're, law firms, and this is new for us. You probably do have permission to do this. I think you do have permission because of the federal standards. You're encouraged to do this as part of your overall plan, but that doesn't exempt you from complying with the overall laws that apply here, including privacy laws. So I personally believe taking somebody's temperature, asking them those medical questions, I think that's a good part of your protecting your workforce, doing what we can to kind of slow the spread of COVID. but it creates some new obligations for companies. How do you view this, Michael?
Yeah, I think everything you're saying is exactly right. Generally, you want to avoid as an employer to conduct medical examinations of your employees before they can enter the workplace. That would be something that would be very much a no-no in normal circumstances. But because of this pandemic, the government, federal and state, have said we are going to permit that because we want to regulate this pandemic and curb it as much as possible. So when you do collect that information, whether you ask questions about symptoms or whether you conduct temperature screens with a non-contact thermometer, whether you ask about travel history, anything like that, if it's related to the person's health, it's going to be considered confidential data. It's going to be considered sensitive data that you need to take precautions to both protect it and to maintain its privacy. So the CDC says follow the EEOC guidelines with respect to the collection of health data. This is really regulated at a federal level by the ADA, and so you have that requirement to maintain its privacy and security. But beyond that, you need to look at the specific state statutes that talk about how to deal with this information, when you can and cannot disclose it, how you have to take steps to protect it, including redacting personal information, et cetera. So I think we'll talk about that a little bit more.
Yeah, and so let's jump into the California, the ETS. So this applies to really any organization that isn't under the aerosol transmissible diseases standard. Most HIPAA, like hospitals and healthcare workers, would be under that standard. Doesn't apply to them because they already have an even more strict standard. So this is relatively new for most companies, and it says that you really have to have a plan. You have to have an explicit plan around how to protect your workers, around how you're going to respond to an incident, kind of like a breach response plan. You have to have this in place, and this is the law, right? This is not just a guideline like at the federal level. If you do business in California and it applies to you, you have to follow this. You have to have that plan. Do you think, are most companies doing this today, Michael, or is this kind of a surprise to most companies?
Yeah, I mean, it's been around for a while. The implementation or the regulation went into effect as of November 30th of last year. So it's been around. I think companies are slowly becoming more and more aware of it. I think if you've got good counsel with respect to employment law regulation or even privacy regulation, you would have been aware of this. This is the law. This is Cal OSHA implementing regulations. It's supposed to be maintained as part of the pre-existing injury and illness prevention plan that most companies are obligated to have. So it can be maintained as a separate policy, but basically you want to comply with this law as soon as possible if you haven't done so already, and you have employees in California. So yeah, I mean, it is law, and we can talk about the specific requirements of that, but there are certain things that you need to take care of and address as part of this policy. And one thing I'll say, I don't want to cut you off, but they do have a model program for this. It's very bare. It's a lot of customization that is going to depend on the specific industry that you're in, the specific locations that you're in. So you need to really look at that closely and comply with the law when you're filling out this prevention plan, and not just fill in the blanks as basic as possible.
Yeah, when I looked at the template plan, it was not as comprehensive as you might have thought. It had a lot of like section headings that it said like put in your plan here, and places that you wanted to put in. I think though one of the key elements of this is I think this means that you probably need to keep records at this point. Whereas I'd say, in our customer base where we have the kiosks taking people's temperatures, lots of large companies using that and deployed all over the different industries. We started off where really only the hospitals were the ones that were retaining those records. And what we've seen is a pretty rapid shift now. And I think almost all of our clients are retaining these records. And I think it's largely in response to this, because what happens is, if you take somebody's temperature, you ask them, hey, are you fatigued today? have you been traveling? This is sensitive information. Everybody knows that. And so one way to deal with that is to just not retain it for any period of time at all, to just, take the information, not write it down, not store it anywhere. And that's one way to kind of lower your risk as a company. But I don't think you can do that anymore. I think because you're required to have records in place, because you have that obligation, because you have to have a response plan, you have to cooperate with contact tracing. I think you're kind of in a position where you need to keep these records. What do you think, Michael?
Yeah, I mean, there are reporting obligations under this ETS. So in some sense, you have to have information kept in order to report it to either employees or the health agencies that require you to report to them. Things like the names of employees and the contact information of employees who have COVID, who are COVID cases. You've got to maintain that information. If you're conducting temperature screening or symptoms assessment, you want to maintain that information to show compliance with the law or the regulations. And not only that is, California passed AB 65, which is essentially a codification of a lot of these best practices, which took effect at the beginning of this year, which has a record keeping requirement of 3 years. So you're maintaining those. You have to maintain those records for 3 years under that specific law. It's not the same as the Cal OSHA ETS, but there are overlapping requirements, and essentially it overlaps to a great extent, if not the semantics and the terminology are slightly different.
Yeah, in fact, we just got a question: how long do you need to keep these? And I think at a minimum, you've got to keep them for 3 years. I think there's an argument that it could be longer than that. Based on the statute of limitations, which varies by state and can be 4 years or more even. And you've got, plaintiffs that could potentially request information, but it's certainly no less than 3 years based on the new law that's effective January 1st. Is that correct, Michael?
Yes, the AB 685 requires employees to maintain records of the notifications they make to employees for at least 3 years. Subject to specified penalties. So yeah, that's at least the minimum amount of time you want to maintain those records. And if you're, you could make a case for keeping them longer. I know that's something you don't want to actually hear, that you have to maintain records for longer, especially with sensitive medical information. But there are instances where you may want to do that. And a lot of this is because it overlaps with other issues that you can face as an employer, like wage and hour claims. Having those records in place, even if they contain potentially sensitive information or health information, they may contain other information that would be beneficial for litigation claims related to something like a wage and hour claim. So,
yeah, and your own defense to those.
Exactly.
We got a question about applicability already, which is our next slide. So the applicability here, so I mentioned if you're a HIPAA covered entity that generally this doesn't apply to you. Technically, that's not how it works. So a HIPAA covered entity is where, you're a hospital, you're a medical provider, a doctor's office or a healthcare plan. That isn't actually how the law works. The way the law works is if the ATD, the aerosol transmissible disease standards apply to you, then the ETS doesn't apply to you. I was just sort of making the comparison that generally ATD applies to HIPAA covered entities. That's not exactly the case. I know within a hospital, for example, that the ATD doesn't apply to like the HR wing, whereas HIPAA applies to it because it's an entity-wide element. But this is, the reason they exempt ATD is because ATD already has all this in it, already has the requirement for record keeping, the collaboration with efforts from state agencies. And so it's not that you're exempt from this, it's just that you already have your own standard that you have to follow. Did I get all that right, Michael?
Yeah, exactly. It's not a specific overlap or a reference to HIPAA in terms of this, but the ATD does include things like hospitals, skilled nursing facilities, clinics, medical offices, things like that generally. So you are going to have pretty much, if you're covered by HIPAA, I mean, I would look at this. I'm not saying this is an absolute blanket statement, but you are more likely than not covered by the ATD with respect to this, to the California ETS.
Yeah.
And then the other thing to note real quickly is just that the exemptions are for employees for working from home or workplaces where there's no one else in the building, right? If it's just one person, then you don't have to comply with these. That makes it easy for a lot of businesses to have a remote workforce to say, we're not going to worry about this now, but this is certainly something you want to have in place sooner than later. So, even if you're not having employees come back to work anytime soon, you want to be prepared for this.
Yeah, so if 100% of your workforce is remote, then right this second, this wouldn't apply to you.
Right.
But eventually, we're going to start getting back together again, or you're going to be on site someplace. So you want to think about it, even in that case. So what are the basic requirements that are stipulated under this new ETS?
Yeah, I mean, the slide kind of says it. Employers, they have to establish the COVID-19 prevention program. Things that are included in that is they have to develop a system for communicating with their employees to report COVID symptoms, possible exposures, possible hazards in the workplace. Things like conducting employee temperature screening is permissible. If they do that, then they should be using non-contact thermometers. There's investigation requirements with respect to reports of COVID-19 infections. And then there's, the notification obligations, where if there are employees, COVID cases of employees in the workplace, there are notification obligations where they have to notify other employees about the exposure as quickly as within 1 day. And then notify the health departments within, I think it's 3 days that they have to notify them. So there's a lot of things going on in this ETS. And that's I guess a summation in addition to the slides we're looking at.
Yeah, there's definitely, when I think about the requirements here, you have to have a plan. You can start with the template that they have, but there's a lot of stuff to fill out there. How do you communicate with your employees is very important in that. How do you provide notice to them if there's an exposure? How do you provide notice to the authorities if there's an exposure? And how do you collaborate with your local health department? But this isn't optional. You've got to do this. You have to have this plan in place, and you have to be willing to cooperate.
Yeah, and this is a case where you really want to work with counsel to identify look closely at the definitions to say, when is it a reportable case? When is it something that happened in the workplace? Our firm does a lot of these COVID prevention policies, and we work closely with a lot of these companies to say, how are we defining this in accordance with what the regulations state? So that's something you really want to make sure that you're not just going by the example provided by by OSHA, because it's not going to help you much.
Yeah, no question about it. You definitely need to involve counsel in this plan and understanding. And we'll talk about this later, but I think you're exposing yourself to significant legal risk later, because plaintiffs are going to go after this, and they're going to want to see, what did you do? Were you taking reasonable care? And I think the security piece of this is one that's easy to pick at. So you want to make sure that you take the right kind of security measures, and that you properly encrypt data and things like that. We'll talk about that a little bit. Vaccinations are here. This is a great news for everybody. It's going to probably going to take quite a while to get to a point where we get enough people vaccinated, but they are starting. There was a Gartner poll recently where 60% of companies said they were going to include vaccination planning as part of their response. Only 8% said they weren't going to include it. The balance of it was just hadn't decided yet. I think everyone is thinking about vaccinations. How does this fit in? Who do we vaccinate? Can we promote this? Can we provide incentives? Can we require it? Can we say you absolutely have to be vaccinated in order to come back to the workplace? So I think this is in everybody's thinking. I'm on a couple of boards, And privacy doesn't come up very often at the board level, but man, this is a topic. Everybody's talking about what are we going to do about vaccinations. So as I understand it, you actually could require vaccinations in order to come back to the workplace, as long as you provide a couple of exemptions. So what are those look like, Michael?
Yeah, I mean, they're generally related to things like religious-based exemptions and other health-based exemptions for that. If they're not able to get the vaccination for some reason, or there's a religious preference to not get that vaccination. But yeah, you're permitted to require generally vaccinations to return to the workplace. Employers are permitted to ask employees if they have been vaccinated. They are permitted to ask employees for documentation of that vaccination, but there's a real fine line there. If you're asking questions about vaccinations, you don't want to go too far and say, get into other health inquiries, because then you're getting into possible claims that you're discriminating based on other health instances and not just the ones limited to COVID. So that's an important thing. You shouldn't, for example, you shouldn't ask why you cannot receive a vaccination, because that could get into questioning about religious motives or exemptions. So if someone says, I have a reason to not get the vaccination, you don't really want to dig too deep into that. So there is a fine line there. And that's, again, why you want to have a plan in place about these types of screens, so that you can make sure that your employees or whomever's conducting these types of investigations or communications with their employees are aware of these limitations.
Yeah, and as I mentioned, we have a platform that you know about, Michael, to take people's temperatures and manage the health check and things like that. We've added vaccination tracking to that recently. Reason I bring it up is because it was kind of hard. This is complicated. How long are vaccinations good for? What kind of evidence do you want to have required? Virtually everybody who's doing this has told us we want to require employees to provide some sort of a signed statement or documentation if they're taking an exemption, whether it's for religious reasons or for health reasons. Yet you don't want specific information, right? You don't want to know what religion they are. You don't want to know what their health condition is, but you want to have something in place that says, all right, you took an exemption. I want to have some documentation of that. You want to upload a copy of a vaccination report. You want to have the dates in place. You want to have very, very strong security around this. This was hard for us to add to our platform. I kind of wonder, how do you do all this? Can you do this with a spreadsheet or with a paper and pencil, or I think that would be challenging. You at least need a ticketing system or something to keep track of this, don't you?
Yeah, I mean, this is going to get very complicated very fast. Not even for small businesses that don't have a ton of employees. The data categories that are potentially going to be there are going to be massive. Where you're going to have, what type of vaccine did they get? What's the efficacy of that vaccine? How long is it going to last? Do they need to get re-upped for that vaccine? In addition to keeping track of the name, the work requirement, the specific industries where they're located, do you have to tie that into contact tracing for reporting and notifying other employees of potential illnesses, et cetera? If you have more than a few employees, and even if you only have a few employees, I think you got to get this in some sort of an electronic system like yours. And you didn't pay me to say that, but it is going to be a daunting task, right? So that's something you definitely want to look into. And not only that is that these records should be maintained separate from a personnel file. They're required to be maintained separately. So placing a spreadsheet in the HR file for this for an employee is not going to work.
Yeah, in fact, one of the questions we got is about the vaccination records requirements around that, keeping that in that security. They're very, very high standards of security around a vaccine, because that's clearly sensitive medical information. Under CPRA, that would be categorized as sensitive information. You have to keep it separately. In our system, we use a redactable security certificate that's individually commissioned, which is kind of our highest level of security. It's not just encrypted by us, it's encrypted with a certificate that only you, the customer, has and you can remove. the second question is, how long should you keep vaccination data? I think it probably falls under the same category as the earlier conversation. It's probably not less than 3 years, is it, Michael?
Yeah, I can't see a scenario where you would want to honestly keep it less than that. There may be some instances where you could justify doing that because this isn't a notification obligation, but all of this is going to be tied together in terms of enforcement by Cal OSHA or plaintiffs' attorneys, and you want to have that available, that information available. So I would say at least 3 years is the right way to go for that, with maybe some look at redacting or anonymizing or limiting the sensitive data as much as possible so that you're able to maintain it securely without a significant risk. All of this should be encrypted. It's sensitive data. It should be encrypted whenever stored, whenever transmitted.
Yeah, for sure. You definitely want to have a very high level of security around this. I think the question, can you offer an incentive to employees for taking vaccinations? I've seen companies doing this already where they're saying get the whole day off if you go get vaccinated. I think that would be categorized as an incentive, wouldn't it, a little bit? Is there any legal issue you think with offering an incentive to get vaccinated?
No, I don't think there is. I think the risk you have to worry about is penalizing people for doing that. If you're going to require it as a obligation to return to the workplace, then you need to consider the impact that has on wage and hour claims, and talk to employment law counsel about how that will affect that. But I don't think there's any harm in incentivizing people to want to return to the workplace. Again, make sure that you're keeping in mind those exemptions that are available and not digging in too deep there.
Yeah, and interestingly, right now, the ETS guidelines and the CDC guidelines say that even if you are vaccinated, you should still continue to take essentially the same measures: wear masks, socially distance, take people's temperatures. A friend of mine went to the Super Bowl and said that they admitted a bunch of healthcare workers that had been vaccinated so they asked them to bring their vaccination proof, but they still took their temperature and they still asked them the same questions, do you feel fatigued today, and things like that. So I think that's something to keep in mind. That may change over time as more evidence builds for the efficacy of vaccinations, but right now you certainly want to just basically have the same standards. And one other thing I'd point out around vaccinations is, like I mentioned at the board level, people are concerned about this. Executives want insight into this. They're going to want to see, all right, we've offered an incentive. We've told people we've asked them to go get that. How many people are claiming an exemption? Not why, but how many of them are? How many have gotten vaccinated? What's the sort of percentage uptake? I think executives are going to be very, very keenly interested in this data, and you want to make sure that data that you present to your executives is sufficiently anonymized so that you're not violating any privacy regulations. Would you agree, Michael?
Yeah, oh, absolutely. I mean, if you're doing business in California, CCPA, you should be aware of the privacy rules there, and the difficulty it is to really, really anonymize data. So you want to take precautions to make sure that if you're providing things like the location the person worked, the shift that they're on, and things like that, you want to make sure you're not inadvertently identifying that person, even if you're redacting their name and contact information. So yeah, but you definitely do want to maintain the confidentiality of these records. And the CCPA, the CPRA is not carving out things like the Cal ETS or the or AB 685. Things like HIPAA are carved out, but not these requirements. So you still have to comply.
They're still in effect. You have to consider CCPA
exactly
in this. Absolutely. Contact tracing. So this is something that is now in many states. It's in the ETS. It's in the directive that we talked about, the federal directive. We've seen a law introduced around this. Basically, it says that you need to cooperate with authorities. You need to kind of do your best to help. And what are the privacy implications of contact tracing?
Well, I guess there's twofold. There are obligations to report to local health officials and to comply with their investigation requests to supply more information. There's a limit to that, right? They have a specific mission with respect to maintaining the COVID pandemic, and you should certainly assist them with that as required by law. But you want to be careful about giving too much data. I would not willingly hand over detailed medical records if you have them about your employees, unless they're specifically asked for it, and then talk to legal counsel about that. But the things like, hey, this person is a confirmed COVID case, this is their contact information, the things that are specified in the law itself, you certainly want to provide to individuals. The other side of that is you need to be able to anonymize the data when you're providing notification to other employees or representatives of those employees as required by the law. So you're required to redact the personal information when providing that notification. And the health records, and the last thing I'll say is the health records are something that is subject to access by the employee under California law as well.
Yeah, and in fact, let's talk about that for a second. So the access by an employee, CCPA carves out employment information. You only have to provide categories of information, but there are existing laws in California that say you get access to this data. So effectively, doesn't it mean that for the most part, if you do business in California, an employee has a right to this information?
Right, they do. Yeah, as an employment record, if it's maintained as part of the employment, the employee has right to access their employee personnel file and their medical records related to injury and illnesses in the workplace. Other employees have access to records related to workplace injuries and illnesses. Again, that should be maintained where personal information is anonymized. But yeah, there are rights to access to that information.
And a question we just got is, are there any rights to delete that data?
That's a specific, I think, use case scenario. I would say generally, the CCPA allows for very broad exceptions to deletion, especially with respect to either legal obligations or legitimate business interests. That's not the phrase they use, but essentially that's what it is. And so I would say it's a case-by-case evaluation, but I could say generally probably you wouldn't have to delete that information, at least for the immediate future following this ETS and probably the next couple of years.
It's a great lawyerly answer. But I think as a non-lawyer, let me say, I don't see any reason why you'd have to comply with the delete request for this. You know, you're clearly given exemptions under CCPA for legal obligations. This is a legal obligation under ETS. So I think, I guess it is a case by case. You should always consult with your attorney, but I think for the most part, you would not need to delete this information no matter who requests it.
Yeah, and again, I think we talked about this very early on in the pandemic, though, there's categories of how much you need to keep in terms of, the degree in which you need to keep the data, right? If it's temperature screening data, do you need to keep this specific temperature for years on end, or the fact that they were below or above, the threshold fever? I think there are ways which you can minimize the data that you've collected and still maintain compliance with the law. But again, you want to look at those things on a case-by-case basis.
Yeah, I think to that case, temperature data maybe keep for 30 days, the specifics, and then just the pass-fail after that, or maybe just the ones that you failed because of that. But you want to be able to defend yourself because, I put this up here as a joke. Nobody's going to sue me over this. I'm just trying to do my best under COVID. Plaintiffs don't care. Plaintiffs will go after you for anything. They have a long memory. And I think what's the most important from my perspective in this is you've got to avoid creating a torts issue, because with my employees, and I think probably most of our companies are like this, we have an arbitration clause. We have protections against punitive damages for the most part. And those things all go away if you get gross negligence allowed by a court. And I think if you're not really following these guidelines, you're not taking the proper security procedures, you're not really following these guidelines, I think you're putting yourself at risk over future lawsuits. How do you think this is going to really be a problem? Or do you think plaintiffs are going to go, it's COVID, I can't really sue over that?
No, there are going to be, and there already are, a lot of claims related to COVID in a lot of different forms. Probably the most typical I've seen so far are the wage and hour types of claims, where people aren't being compensated for the time they spent doing COVID screenings, the expenses they have to buy PPE or take other precautionary measures. Those are things that get into the wage and hour type of claims. But there are things like the tort claims based on wrongful death related to exposure in the workplace because the failure to take proper precautions or comply with the guidelines or adopt, reasonable safety measures, or even failure to warn. All of those things are addressed by these ETS and even AB 685 that say there's a notification requirement almost immediately if there's a case. And so not only can you be subject to a plaintiff's suit for failure to warn or negligence or even the wage and hour violations, but Cal OSHA can come in and fine you with civil penalties. What 685 does actually is create a rebuttable presumption that you've created of a serious offense if you fail to take the precautions laid out by 685. The fines there can be substantial. They can be, I think it's up to $25,000 for the first violation, and any subsequent violations after that are an additional $25,000. So you want to take even the reporting obligations. If you fail to maintain the records or you fail to notify people, those can be tens of thousands of dollars each for those violations. So there are a lot of opportunities to be sued by both plaintiffs and the government for failure to comply with these rules.
Yeah, it's really stuff we have to take very, very seriously. One question we just got, Michael, what about with regards to third parties? We talked a little bit about what you need to do with your records. What if you have a third party that's collecting temperature data or what kind of obligations? You probably want something in your contractual relationship with them that says that they're going to follow the guidelines. Is that the basic guidance you'd give?
Yeah, oh, absolutely. There should be a lot of due diligence with respect to any sort of vendor who's going to be processing personal information on behalf of the company, and especially sensitive personal information. You want to make sure that they've got the proper security in place to make sure that that data is protected when they're processing it. Something like encryption during transit, encryption during storage, redaction if at all possible. You also want to look at the fact that the CCPA is going to require you to do that. You need to have the protections in place to say this service provider for us is not going to use the data they're collecting for their own purposes. So a lot of things go involved with that. I gave a talk last week about third-party due diligence and data processing, so I'm well equipped to speak to anyone about that. But yeah, you certainly want to have a vendor questionnaire in place to say, how are they processing this data? What protections are they offering? And really dig deep, especially when you're talking about sensitive personal data.
Definitely. Other considerations, hey, we have a vaccine, so it should just be a couple more weeks until we don't have to deal with this anymore. Right, Michael?
Yeah, that's it. I think we're all going to be back in the workplace, by March. We were talking when we were planning for this. I saw in the Orange County Register yesterday, my local newspaper, they said one article cited that based on the current vaccination rate worldwide, things will get to herd immunity in about 7 years. So, and that's taking into account the status quo. So things are not going to go back to normal. This is going to be in term for, a long time. I think the AB 685 contemplates at least till 2023 that we're going to be dealing with this, and that law's in effect until that time. It could get extended if it needs to, but we're not going anywhere. And this is going to be kind of the new lay of the land, the new normal with respect to workplace precautions and data collection and screening.
Yeah, obviously, I was just kidding about the couple weeks thing. I think that there's no question that this is going to be in place for a while, as you mentioned, at least until January of 23. It could be longer. This could be effectively a long-term situation that we're in. We should think about that. CPRA does impact this a little bit. It doesn't impact it until January of 2023. As we've just talked about, it could easily be still enforced by then. And it is very, very clearly, though, categorized as sensitive data. CPRA has a new concept similar to GDPR of sensitive data, things like your sexual orientation and your race and medical information about a consumer or an employee clearly fall under that. So there are some special considerations for CPRA. Anything to add to that, Michael?
Yeah, so we have a couple of existing laws that apply generally to businesses in California. The section 1798.81.5, which is the data breach notification law, includes information regarding an individual's medical history or diagnosis by a healthcare professional. That could include things like COVID-19 results. And then the CCPA includes that within the definition of data that's subject to the private right of action if there's a breach of that data. So we do have existing risks related to CCPA, especially for the failure to maintain the security of that sensitive personal information. And then again, once you get into CPRA, you have the rights afforded under the law with respect to the limitation of the use and the access to that data. But honestly, COVID-related data should be limited in use anyway. You should not be using COVID screening data for any other purpose except to comply with the law and maintain the health and safety of your workplace.
And one question that just came in is what about the 1-year look back period? So it's effect January 1st, 2023, but effectively you'd have to look back a year at any data you'd have to January 1st, 2022. Is that correct, Michael?
Correct. The look back period starts on January 1st, 2022. So you would have that, the right of access. Again, there's the right to access this information anyway by employees. So it's not really a question of do you need to provide it in a CCPA subject access request. But if you are going to do that, you should obviously take steps to redact the sensitive data in accordance with the regulations provided for the CCPA. And even then, I would say if there's anything that could be considered health-related information, you would not want to provide the actual data, but the category of that information.
Yeah, in fact, oops, I'm going backwards. In fact, in our platform, we take very special security procedures around this data because it is such sensitive information. We create a root certificate that has to be commissioned individually for each device. And then it is a redactable security certificate, meaning that is encrypted data. And the key to decrypting it is you can actually revoke that. And so if you did have a compromise in the information, you'd be able to revoke that certificate, and effectively at that point, you don't even qualify as a breach if you've properly encrypted the data and you've redacted the certificate. We've gone to really pretty significant measures in our platform to be able to make sure and maintain the security of this information. Do you think, is that overkill, or is that kind of best practice for this kind of data?
Yeah, I mean, the law under the data breach notification law says it's not a breach if the data has been encrypted and the encryption key is not also breached. So encryption's I think a lowest common denominator in terms of protecting sensitive health information, and it's certainly not overkill. I think it's the lay of the land for what you want in a service provider with respect to this data. The second thing I'll mention with respect to subject access requests is you have this right under the CCPA and even under the CPRA to have authorized agents request this information on the consumer's behalf. I would be very wary as an employer to release any sort of sensitive medical information about an employee, even related to even temperature screening or anything, or symptom screening, to an authorized agent, unless you have a signed authorization by that employee.
Unless there's a power of attorney that you've got signed by the employee. I agree with you. I don't know if you saw the consumer report that was just issued a couple days ago, where they went through and tried to make agent requests at 21 companies, and they found half of them just failed miserably. And I think that's going to be a big focus of theirs. But I agree with you. I'd be very, very cautious about issuing any type of information like this. This is very sensitive medical information. One other thing I'll just point out on the left side there is the user access controls. You need to make sure that you keep this information separately and segregated, and that you control who has access to that information in a way that is separate and segregated, unless it's properly anonymized. You want to, executives want insight into this. They want to see reporting on it, but you have to anonymize that correctly. The access to this information needs to be very, very closely controlled. People want to see reports on this, though. Executives want to know what's going on, much more so than for most of the stuff that we deal with in security and privacy. Who's getting vaccinated, who's coming in the office, how many people are rejecting, things like that. But you have to anonymize this information, and you have to do it in such a way that you can't somehow inadvertently figure out who it is. If you only have one attorney in your company at a particular office, and you've said, oh, it's the attorney at office A, then you've effectively identified that person. So you got to be careful about this, and yet everybody wants to see insight into this.
Yeah, I mean, there are methods and methodologies for properly de-identifying data or anonymizing data. When you're looking at aggregated data, I think it's a very, very beneficial data point with respect to how your company is responding to COVID precautions and regulations. And it actually can help improve your compliance with this by saying, look, we've identified risks areas in terms of a lot of people are coming in, or a lot of people are working at this particular location. Can we spread out and mitigate the risk, et cetera? So there are ways that the aggregated data can be very, very helpful in identifying ways to limit risk. But again, you need to make sure that you're not including personal information in that aggregate data.
Definitely. We know that there are laws around the world around this as well, privacy laws that you have to respect depending on what jurisdiction you're in. Certainly in the EU and Canada. China has some new elements to this. India has a proposed law. Almost everybody, if you operate in other jurisdictions besides the United States, you definitely want to consult with your attorneys about that. But across the United States even, I think every state has something that's been introduced related to COVID that mentions privacy in one form or another. New York has many, many laws that involve this. We've talked about California a lot. Connecticut, Alabama have very specific laws related to this. I think generally, if you're following the ETS in California, yes, you want to look at the specifics of that versus the federal directive. Yes, you want to look at your local health ordinances and your local state pieces, but pretty much that is kind of a best in breed set of laws. Would you tend to generally agree with that, Michael?
Yeah, I mean, I think that because it follows the federal OSHA guidance almost to a T, that you can expect that any other OSHA regulations in other states are going to be similar to what California has in place. Again, I agree with you. You certainly need to look at the fine print in all of the regulations where you have employees and workplaces. But yeah, California, I think, is setting the benchmark, as it does for a lot of things privacy in terms of the nationwide standard.
Yeah, and I think that's definitely true. If you are in Alabama, Connecticut, or New York, I would especially advise you to take a look. They have special contact tracing processes that you need to follow to collaborate there. But generally speaking, I think the ETS is a good nationwide standard. We do have laws that are pending now in Washington State, Virginia, New York, North Dakota, Texas, Oklahoma, Minnesota. Privacy, more general privacy laws. How would you see those affecting the data that you're collecting on the horizon?
Yeah, much in the same way the CPRA does and is going to. You're going to have overlapping regulations where you have not only the employee-specific laws addressing how privacy is maintained for employee data, but also these general omnibus privacy rules that apply to all residents of the state. So you want to make sure that you're taking into account both of those things, looking for carve-outs where they exist or exemptions where they exist. A lot of them are going to come, operative I think Washington's going to become operative if it passes in 2023. So there is time to comply with those things. But if there's a COVID specific privacy regulation passed by a state, it's not going to wait until 2023. It's going to be more direct. So keep an eye out for those. Talk to you and I about where those updates are coming from, and be prepared. And the last thing I'll say is if you are an international employee or employer and you're processing data centrally in the United States, you do have to worry about things like the Schrems II decision and the standard contractual clauses. How are you going to get around the processing of HR related data in the US? So there are, we didn't really talk about these here. We were more focused on California, but there are additional considerations if you are an international operation.
And Michael's a great resource if you need to consult someone on that. So just to summarize, I think we're about out of time here. That I think previously you might have thought, well, I should just destroy data immediately if I'm taking health-related data. I don't think that's possible anymore. I think you have to hold on to it for most likely 3 years or more. And I think because of that, you need to take very specific security precautions around it. If you do business in any way, shape, or form in California, you got to take a look at the ETS, these emergency temporary standards. You need to have a plan. You need to know how to handle an outbreak. You need to have measures in place to try to prevent the spread of COVID as much as you can. And I think that this is the law in California. I think it's important too, just to protect yourself legally. Vaccinations overlay on top of that. It's great that we have it, but it generally does heighten the situation. That is sensitive information. It's health data. It's something you need to consider, and people want insight into that. Make sure that you communicate with your organization. This is the most important guideline that we could possibly give you, is just communicate with your employees. These are your employees. They're the heart of your company, the most important element of your company. Tell them what you're doing. Tell them what you're doing with regard to your policies and procedures. What are you doing with vaccinations? Be transparent. Tell them what's going on. That, I think, is the best way to avoid conflict with your employee base. Any final thoughts from you, Michael?
Yeah, I would say the last thing is just to keep in mind that these are evolving standards. Just as the data comes in about COVID and how the pandemic has affected employees and the infection rate, the vaccination rate, all of those things. These are temporary standards, even though they're maybe here for a couple of years. These are temporary standards. The right to collect, conduct temperature checks is a temporary authorization in exemption from federal law. So you need to be aware of how these regulations, the laws, the guidance is going to change in the future. So just maintain, some sort of vigilance in that respect.
All right, Michael, thank you so much for joining me today. As always, it's a great webinar. I really appreciate your help. And with that, let me turn it back to Ryan.
Thank you, Dan.
Thanks, guys. Great information. We are out of time. We got a lot of great questions. If you did not get a chance to submit one, or you think of one later, you can email us at hello@truyo.com and we'll get you a response as soon as possible. As I said before, we will be sending this out to all the registrants, so watch out for that. Thanks again, stay safe, and have a great day.